Hi, I'm Byron Moore, and I'm here at the Moore Law Firm, and you've probably arrived here from clicking on our video library on our website. Welcome. This video is focused on wills. There's a variety of other videos addressing other topics here in the library, but this particular one is on wills. So, what is a will? A will is a way for you to designate who gets what when you die. When you pass on, this instrument will lay out exactly who's going to get what time frame they're going to get it in, and who's actually going to be in charge of the process. Now, a will goes through probate. If you wish to avoid probate, there are a variety of other mechanisms to do that, including trusts, both irrevocable and revocable, and other different vehicles and entities that are not trusts, like limited liability companies or bank accounts that can be used to avoid the probate process. But a will goes through the probate process. And the individual who takes that process through is what we call a personal representative. It used to be called the executor, but now it's called a personal representative. So here in Washington, the personal representative is the individual who takes the estate through probate. Now, if you don't have a will, Washington State sort of has a pre-planned will, and you will not like the outcome. It divides up your possessions in a very unique and rather archaic fashion. So make sure you have a will in place. Now, in a will, you can have a trust. We call it a testamentary trust. And a testamentary trust allows you to put some controls and timelines on when individuals are going to receive certain items, whether that be real property or personal property out of your estate or other assets. So that is what a will does. Now, in order to have a valid will in Washington State, you need to have several elements, is what we call them, present. You have to be 18 or older. You have to know the objects of your bounty, which means you know what you're giving away. You have to be of sound mind, and you have to sign the will in front of 2 witnesses. Then those 2 witnesses have to sign an affidavit in front of a notary public. Now, here's where often a misconception is: people will have 2 individuals sign the will and they think that they have a valid will, because they do. However, when it comes to probate, those 2 witnesses will have to go and testify in court that they actually saw you sign the will, or that you attested to them that you had signed the will. Obviously, that's a major inconvenience, and if one of those witnesses dies, then you are out of luck and won't have a valid will for probate. So the key here is to get that affidavit, and that's where another misconception or misunderstanding comes into play, is that people often just think that they can get their will notarized and they've got a valid will. They don't actually have a valid will at all there. So make sure that you go to an attorney who's actually going to walk you through and do it the right way. And those are some of the things that you need to have present in a will. So that, in a short nutshell, is what a will is and what it provides. I'm Byron Moore. You can reach me at 293-9867. I'm here at the Moore Law Firm in Wenatchee, Washington, and I'm here to help you understand your estate planning options. Thank you.